Kennebec Journal's website. We're here this evening for the district attorney debate for Kennebec and Somerset counties for prosecutorial District 4. It'll run this evening until about 8 p.m. Our candidates this evening are Republican Derek Banda and Democrat Megan Maloney. The moderator of our debate this evening is former Chief Justice of the Maine Supreme Judicial Court, Dan Wathen, who still practices law and teaches part-time here at UMA. My name is Taylor Kilgore. I am the Secretary of the Board of Directors for the University of Maine at Augusta's Alumni Association, and on behalf of us in the Kennebec Journal, we welcome you this evening, and we thank the University of Maine at Augusta for the use of the Jewett Auditorium this evening. We would like for everyone here joining us in Augusta to know that there will be a small reception in the Danforth Gallery across the hall at the end of the debate, and you're all welcome to join us. The only thing that we're asking currently is that we hold applause until the end, otherwise we might be here all night. And with that, I think I'll hand it over to Justice Wathen.
Good. Thank you very much, and good evening and welcome to all of you. My name is Dan Wathen. I live here in Augusta, and for the past 47 years, despite my youthful appearance, it's been that long, for the past 47 years, I have been involved in one way or another in the criminal justice system here in Kennebec and throughout the state of Maine. I've been a defense attorney, I've been a Superior Court judge, a Supreme Court judge, Chief Justice, and if you count minor traffic offenses and fish and game violations, I've even been a defendant. So I've seen it from all perspectives. So I want to thank the Kennebec Journal and the UMA Alumni Association for hosting this debate. And I also want to thank these candidates for seeking this important public position and for their willingness to share their views with us this evening. And I want to thank all of you for attending, and I want to begin by asking all of you to give these candidates a round of applause. And as they said in the presidential debate, we'll thank you for holding applause or any other audible response until the end so that we can treat this as sort of a job interview and less of a debate, that you can have an opportunity to hear, and I've seen some of the questions that you've brought, so you can have an opportunity to hear what they have to say about some important positions. And at the end, we'll give them both a rousing round of applause, and we'll all have had that opportunity. The debate format this evening is that each candidate will have an opening statement, and by coin toss we've determined that Ms. Maloney will begin and Mr. Banda will follow, and then the questions I will then pose, and each will have 2 minutes for response, and I'll alternate from one to the other. And I've asked the candidates not to pose questions to each other, but to treat us as the audience and the questioners, the people who are looking at this job interview, and to talk to us. Sometimes I may have a follow-up question, and if I do, I will address it to both of the candidates, and they'll have a minute for that. The timekeeper will indicate when a candidate's time has expired in each case, and we have invited, and you folks have written down questions, and if you have them, put them in the box, and as I've picked up the first batch and looked at them. They're very good. And if you have more, put them in the box, and as we go along, they'll be brought up to me. And to the extent that I'm able to, I'll incorporate them into the questions. Some of them are questions that I had in mind, and so you may not hear it precisely in your word, but hopefully they'll address the questions that you had in mind. And I'll try to work as many of your questions into the debate as possible. At the conclusion of our time for questions, we will have a 3-minute closing statement from each candidate, and then we will retire to the reception. I got to lay my watch down so I know exactly how much time we have here. At this point, we're ready to proceed. And so, Ms. Maloney, we'd be happy to hear your opening statement. And if you wish to stand, you may, or sit, however you'd like.
Thank you. Thank you to the Kennebec Journal, to the University of Maine at Augusta, to Justice Wathen, to Mr. Banda, and to all of you for being here tonight. My name is Megan Maloney. When I was 12 years old and living in the Tall Pines low-income housing project, my best friend was killed by a drunk driver. The driver was wealthy, and he never saw a day in jail. At that moment, I knew injustice, and I promised to spend my life fighting for justice. I fought my way from the projects to a full scholarship at Swarthmore College. I worked in the Philadelphia District Attorney's Office in the homicide unit with families of murder victims. I worked in Washington, D.C. as an investigator with the Public Defender's Office. And then I won a fellowship, a Truman Fellowship, to attend Harvard Law School, where I had the privilege of working on an amicus brief for the United States Supreme Court. Over 15 years ago, I graduated cum laude and went on to fight for justice as a deputy district attorney in the trial unit in Portland, Oregon, until I was promoted to run the multi-million-dollar civil forfeiture unit. When my husband, who is here tonight, graduated from naturopathic medical school, we moved home to Maine because this is where we wanted to raise our children. I worked as an assistant attorney general for Maine, trying cases in Waterville, Skowhegan, and Newport. I have the honor of being endorsed by Sheriff DeLong, 3 former attorneys general, Kennebec and Somerset County commissioners, and Elliot Cutler. Now, last week I was again confronted with a situation of injustice. I was volunteering on a Saturday morning at the homeless veteran stand down in Togus when a veteran walked into the room, looked at me and said, "You look familiar." Then he took a step back, pointed at me, and said, "You put me in jail for 30 days. He was right. At the time, I was an assistant attorney general, and I had no other options. At the time, the Veterans Treatment Court did not exist. I worked to change that last year when I introduced a bill to establish veteran treatment courts in the state of Maine. That bill became law, and now prosecutors do have an option, instead of incarceration, to offer our returning heroes when they come home. We must continue to honor our veterans even as we fight to keep our communities safe. We must do this and other programs in order to be smart on crime. Thank you.
Thank you. Mr. Banda.
Thank you, Mr. Wathen, and I want to also start by saying I want to thank Scott Monroe, the city editor of the KJ, for helping set up this debate. I'd like to thank the Kennebec Journal and the UMA Alumni Association for sponsoring the debate tonight, and the University of Maine at Augusta for allowing us to use their facilities. I'd like to thank you, sir, Mr. Wathen, for taking the time out of your busy schedule to moderate. I'd like to thank Ms. Maloney for agreeing to be here to the debate and everyone that showed up for the show of support tonight. This is an extremely important race. The results of this race for district attorney will have a greater impact on the lives of the people of Kennebec and Somerset counties than many of the other officers on the ballot next Tuesday. That is why I'm here tonight asking all of you to put partisanship aside when you consider the office of district attorney. That's because the district attorney is the chief law enforcement officer for the district and is entrusted with protecting public safety. It is a professional office, not a legislative office, and it requires leadership by someone with relevant skill set and experience to be successful in the courtroom, not in the legislature. This race is not about party, it's about experience. I have spent my entire career here in Maine. I was educated in Maine schools, and I'm proud to stand with the rest of the alumni of the University of Maine system. My legal work as an attorney has been exclusively focused on Maine criminal law, and I have been doing it for more than a decade. In that line of work, I've been on both sides of the courtroom. First as your assistant district attorney in this district, then as a criminal defense attorney handling criminal cases all over the state. The very types of cases that the district attorney's office handles, like OUIs, domestic violence assaults, sex offenses, drug offenses, and serious violent felonies, unlike the work of my opponent. As a prosecutor, I work directly with former District Attorney Everett Fowle and then Deputy District Attorney Alan Kelly. And I was in charge of all court operations for the Augusta District Court branch office, trying serious cases hands-on. As a criminal defense lawyer, I have tried serious criminal cases over the entire state of Maine. In both roles as prosecutor and defense attorney, I've had the opportunity to work with and against some of the best trial attorneys around. People like Alan Kelly, people like David Crook, Roger Cates, Lenny Sharon, Walt McKee, Pam Ames, Ron Bourget, Tom Nail, David Geller, Sherry Tash, and many others I don't have time to name. The only time my career has taken me outside Maine has been to serve my country, which I did proudly as a member of the Maine Army National Guard for many years. My leadership and management experience comes from a military background. I'm honored that the Maine State Troopers Association has endorsed me to be your next district attorney. Most of you are likely already aware that our former DA, David Crook, a Democrat who served as the DA for 24 years, has also endorsed me. They're joined by multiple past and present prosecutors, police officers, and members of the legal community who are here tonight. It's time to get past the slogans. It's time to get past the gimmicks and the pandering to special interests. It's time to look at one's legal experience and how that experience is relevant to the Office of District Attorney. I'm Derek Banda. I know what a day in the life of a prosecutor is. I've been there, I've done the job, and I can do the job. I welcome your questions tonight.
Thank you. The first question is for you, Mr. Banda. And I would say that there's a textbook that I use in teaching a course here at UMA, and it says this about the role of the prosecutor. And the question may be answered very easily, or it may take you a little bit longer. But it says this: prosecutors are the most powerful officials in the criminal courts because of the broad discretion they exercise. They screen felony arrests to determine whether charges should be filed, and if so, which charges. If they decide not to file charges, the suspects are released. At later stages of the criminal process, they may decide whether to seek a grand jury indictment, oppose bail for a suspect, drop or reduce the charges they initially filed, and plea bargain or refuse to plea bargain with the defendants. I'm going to come back and talk about some of those functions in more detail as we go along. But I want to begin just by asking, in general, do you agree with that description of the job that you're seeking?
There's no question, 100%. The core role of the district attorney is the exercise and the trusting in the district attorney, the exercise of that core function, which is the prosecutorial function. And the question that every district attorney should ask in any case that comes across the desk is, did a crime occur? Can we prove it? Should we prosecute it? And if we should prosecute it, what sentence should we seek? And that's the core function, and it's the most central function of the district attorney. And that's why I always have said that in my candidacy, that it really is about prosecuting the right people for the right crime for the right reasons. And that is the core function of the district attorney.
Ms. Maloney, same question. Do you need it repeated, or do you have it? Okay.
Thank you. I also do see this as the core function of the district attorney. I remember that as a deputy district attorney in Portland, Oregon, which is the term used here as assistant district attorney, that we were given wide latitude to take to court the cases that we felt strongest about and to reduce charges if we felt that that was necessary, so that I was able to feel that the cases that I brought forward, the defendant truly was guilty. And I appreciated the district attorney, Mike Schrank, in that he really empowered his deputies with the ability to make sure that we felt a crime had been committed before we brought a case to court. Now, the district attorney also has another function in addition to what the deputies have to do, of course, because the district attorney also has to handle the budget for the office, which in this case is over $500,000 in Kennebec County and over $300,000 in Somerset County, oversees over $100,000 of restitution funds, and also often works with the legislature in talking about proposed crimes, new crimes, and new proposed legislation. When I was on the Judiciary Committee, I would often see District Attorney Everett Fowle, Chris Almay, Jeff Rushlaw, even Todd Collins, and they would come to speak about various items that we were considering. So that's also important. And then the last thing I want to add is that I've been talking with people in law enforcement, and the Fraternal Order of Police, as well as others in law enforcement, have told me that the #1 thing that they would like to see from the district attorney's office is enforcement of the civil forfeiture laws. That the civil forfeiture laws are a great crime-fighting tool. It enables us to remove the tools of the crime away from the person who has committed the crime. And when we take away the tool, that can often be a bigger punishment even than incarceration. And so that's something that I think is extremely important and I do think should be pursued.
The discretion, at least in the legal circles, really means that the actor has a choice. You can do one thing or the other, and it's sort of up to you. Plea bargaining plays a very prominent role in the movement of cases throughout the courts in this state and particularly in this prosecutorial district. So I would ask you, and this is, what will your policy be on plea bargaining, and how will you implement that policy throughout the courts in the two-county district, bearing in mind that you're not going to be in every court every day?
Thank you. That's a great question. I think that in order to be smart on crime, what we need to do is differentiate between different types of crime. That crimes where we have a violent act has occurred, so such as domestic violence, violent crimes against children and the elderly, the pharmacy break-ins, home burglaries. These are crimes that have to be given the utmost priority, and these are the ones that we should be taking to court. The non-violent crimes, which is unfortunately, actually I should say fortunately, the non-violent crimes are the majority of the cases that we face. Those are the ones where I would be open to a plea bargain that incorporates some sort of rehabilitation. That what I would like to see more of is doing things like the Veteran Treatment Court, expanding that as much as possible. We also have the Co-occurring Disorders Court. I'd like to see us have a drug court in Skowhegan. Opportunities where we can rehabilitate someone and not just be focused on incarceration. Because frankly, incarceration is very expensive. We spend $56,269 a year per inmate in Maine to incarcerate someone. So for nonviolent crime, I would be looking for plea bargains that incorporate alternatives, that can introduce people back into society, that can help them to be a functioning member of society, whereas for the violent crimes, that's where I would be looking at trying the case and looking for the longest sentence possible.
Okay. Mr. Panda, the same question?
Well, I don't particularly like the term plea bargaining. The district attorney's office makes a sentence recommendation. And that sentence recommendation takes into account a variety of factors for any one particular given case. It might be the severity of the case, might be if there's any injuries involved, whether the person has a criminal record. There's a whole host of an analysis that goes into what do you recommend as a prosecutor on a sentence on a particular case? What is the value, so to speak, of that case? What are you going to ask for? And it's not so much plea bargaining, because you may get a defendant who comes in and wants to take responsibility. And you need to know what to recommend for a sentence. Now, I don't think that it makes sense to just say, well, we're going to take a tough approach on domestic violence, assault, robbery, and other things, which, Ms. Maloney, you've said in the past that you're going to take a zero-tolerance position on domestic violence. And quite frankly, I mean, I have to say here that represents a fundamental misunderstanding of the criminal justice process, and particularly domestic violence cases. To take a zero-tolerance policy on domestic violence means that you are now victimizing the victim. And you're victimizing the victim because justice delayed is justice denied. And if you don't seek to get convictions on domestic violence cases early in the process, and you allow that person to get out on bail, there's a couple things that are going to happen. They're either going to violate bail and go back and have contact with their offender, or now that you've said that you're not going to plea bargain, you are now playing into the hands of the defense. And I'm a member of the defense bar, and I can tell you every defense attorney who's heard you say that is just waiting to have you implement that policy, because delay will benefit them. They will benefit them because the victims, in more cases than not, as time goes on, begin to not cooperate with the prosecution. And it's not because they don't want to see punishment. It's because many times the financial burdens that are imposed on them when their significant other is removed from their home and they're not allowed to have contact with them, puts a huge financial strain on that victim and huge pressure on that victim to get that case over with. And by saying that you're not going to negotiate domestic violence cases, you're actually re-victimizing the victim, and that is not the policy to take. We need to take a case-specific look at every case, and not just felonies, not just misdemeanors, but case-specific look based on the individual circumstances.
Let me ask a follow-up question on that point, and it's one that has been mentioned by several people in the questions that they've submitted. There are often, in many types of cases, child abuse cases, domestic violence cases, any type of case, there are often reasons that arise that you didn't anticipate in the beginning. The victim suddenly doesn't want to testify, or is unavailable, or is a little shaky as to whether they will make an appearance. And you're confronted sort of with the situation of, is half a loaf better than no loaf at all? And so I'd sort of ask you first, and then with the response, how do you deal with that? And is there such a thing as the half a loaf?
So when I was a deputy district attorney in Portland, Oregon, we had a zero-tolerance policy on domestic violence. And I've spent a year overseas spending my time working to end domestic violence. I've discussed the domestic violence zero-tolerance policy here in Maine with Julia Kolpitz, who's the head of the Maine Coalition to End Domestic Violence, and those of the Family Violence Project. They would like to see a zero-tolerance policy. And I've seen it work, and I know that it can work. It has nothing to do with letting people out on bail. What it has to do is with going forward with every case. We have to first make sure that the person has committed a crime. And then, even if, as Justice Wathen was discussing, the victim doesn't want the case to go forward, we make the decision to go forward and to try that case if a crime has been committed. That's always the threshold. You always have to make sure that a crime's been committed first. This is a policy that I came to after speaking with countless victims, particularly at the Domestic Violence Speak Out in Waterville and the Domestic Violence Speak Out in Skowhegan. And what I'm hearing from victims is at the time of their abuse, they are in a place where they want the state to take over. I've heard from victims who have had their bones in their neck broken, from people who have been strangled to unconsciousness. And their cases in some cases, they're not going forward because they're scared. And they want the state to say, this behavior is unacceptable. We are going to pursue this case, and we're going to take it out of your hand because a crime has been committed. And so I do think that we do need to go forward with those.
Same follow-up for you, Mr. Benda.
Well, I haven't been to any of those places, but I've been right here in Maine. I've been in Augusta, I've been in Waterville, and I've been in Skowhegan. And I've been actually handling those domestic violence cases. And I've put more people in jail for domestic violence than I can remember, quite frankly. And I think it's about time that, as somebody has said, and I'm going to say it right now, the suggestion that this prosecutorial district has not done a good job with domestic violence is offending. That does not at all do justice to the work that Everett Fowle has done, that Alan Kelly has done, and that David Crook has done before him. This district was a model of prosecution for the entire state. For all of the 8 prosecutorial districts, we were the model. And we've put people, plenty of people in jail for domestic violence. No office is perfect. But when you get a victim that comes to you and says, I'm not going to testify, if you subpoena me, I am not going to show up. You can throw me in jail and I will not answer questions when you put me on the stand. How does zero tolerance work then? You have to find creative ways to get convictions, because if you don't get convictions, you can't get the rehabilitation. You can't get the counseling. You can't get the certified batters counseling. You can't get the alcohol counseling. We can only enforce that if we get a conviction. And you need to have creative ways to do it. We've done that, and primarily it's been with the bail code. We've done that with the bail code, and it's been a very effective way. I know Ms. Maloney doesn't know that because she hasn't been doing these cases, but that's how you enforce the domestic violence laws, is you effectively enforce the bail code, particularly in situations where you have victims who are not cooperative with the prosecution.
I'm probably going to get confused going back and forth, so if I do, forgive me. But I think this next question is for you, Mr. Benda, first. And you both made reference to the fact that one of the choices and decisions that a prosecutor has to make is being sure that the crime has been committed and then going forward with the prosecution. And so I'm going to ask you, what principles will guide you in making what are often difficult decisions to charge an individual with a particular crime? For example, you have a largely uncorroborated allegation of rape that you nonetheless believe, but there's nothing much beyond what the victim themselves have to say. How do you deal with that?
You have to take every case, every individual case, on a case-by-case basis. And that decision to charge should not be made until you are convinced that the case can be proven beyond a reasonable doubt. So you have to look at what you have for physical evidence. You have to look at what you have for witness statements. And if the case can't be proven beyond a reasonable doubt, you can't bring the case. I mean, it's as simple as that. But where does that exercise of that judgment come from? How do you know, and how does any attorney know, how does any prosecutor know whether they can prove a case beyond a reasonable doubt? The way you know that is by having been in the courtroom, litigating cases, doing jury trials, making the arguments before citizens, and getting a sense of how these facts play out in the courtroom in front of the average citizen. And without that wisdom, without that litigation experience, which I have here in this state, doing jury trials for over 10 years, and this is a huge discrepancy between myself and my opponent, is I have been doing jury trials here for over 10 years in this county. Ms. Maloney has not been doing criminal jury trials in this county at all. And you need to have the wisdom and the experience to know what works in court and what doesn't work. And that's part of the wisdom and the experience that goes into deciding, do we bring a charge and can we prove it beyond a reasonable doubt? But it's a fact, it's a case-specific analysis, but it takes that judgment.
Same question for you, Ms. Maloney.
Thank you. I have been trying cases in Portland, Oregon. I have been trying cases in Maine. My courts were Waterville, Skowhegan, and Newport. That is where I have tried the bulk of my work. I have also done some cases in Augusta. And it also matters that I worked with families of murder victims in the Philadelphia District Attorney's Office and got experience with families of murder victims and received experience from that as well. It is not just, however, from trying cases that you learn when to charge someone and when not to charge someone. It is also important that you have a breadth of experience. And I think it's critical that I am also a rostered guardian ad litem in addition to being an attorney. Because as a rostered guardian ad litem, it means that I had to go through substance abuse counseling, I had to learn about victims, I had to learn about battered women syndrome and how it affects victims, and why it is that they would be reluctant to go forward, but if the state does take over and goes forward with the case, why it is that that can be successful. I had to learn about child psychology. These are all areas that will be critical to understand in deciding whether or not to charge someone with a case such as rape. In my work as a guardian ad litem, I was able to do child protection cases for the state that lasted several months. In fact, I was in court this morning on a guardian ad litem case, which I have been working on for the past 2 years. That type of time, that behind-the-scenes time, seeing these parents again and again, interviewing the child again and again over a period of months and years, gives you an understanding of people that is very difficult to get when you only see people from the side of prosecution or defense. So while I have the experience in trying cases, I also think that it is critical that I have the behind-the-scenes experience evaluating cases and bringing that evaluation to the court and saying to the court, this is what I think should happen in this case. Because that's very similar to what a district attorney needs to do in deciding whether or not to go forward with a case.
Thank you. The next question, I'm going to shift gears just slightly. I'll come back again. I'm not leaving any of these issues, but shifting gears slightly, because Riverview Psychiatric Center is located in Augusta and here in Kennebec County, the petitions coming out of the hospital for reentry, modification, treatment plans, and so on and so forth are all handled here in Augusta, no matter where the person may have come from. And they're either handled by the district attorney's office, or if it's what would have been otherwise a homicide case, may be handled by the Attorney General's office. But the DA here in Kennebec, Somerset County has extensive involvement in decisions involving the reentry into the community of persons who have been found not criminally responsible because of mental illness. And so I would ask you first, how will you go about assessing these cases, and what is your view as to how you will present them in court on those occasions?
Thank you. This is a question that I have been extensively involved in because this is an issue that primarily affects people who live in Augusta. We have currently a concern where people who have been found not guilty by reason of insanity, who are at Riverview, used to be released into group homes on the Riverview campus. Those group homes are being closed, so that people are now being released to group homes in the community. I happen to live a few blocks from one of those group homes. So it's something that interests me directly, and it interests the community directly. So I've attended several meetings on this. The relevant statute is in Title 15, it's Section 104A. And what concerns me in looking at this statute is that, well, first of all, the district attorney who covers Augusta, which would be one of us, will always have the right to testify at these hearings because the person is always going to be released into our district. So I think that's important. But second of all, the statute says that the office, that the testimony of an independent licensed psychiatrist can be had at these hearings. In addition, that we need the testimony of a forensic evaluation and the testimony of any independent psychiatrist or licensed clinical psychologist who is employed by the prosecutor and has examined the person in any other relevant testimony. That part is not being done because, frankly, we can't afford it. We can't afford to hire an outside independent person to evaluate someone before they're released into the community. Because of budget cuts, because we're unable to afford that, it is my position that those who have been found not guilty by reason of insanity for homicide should not be released into the community until that evaluation is done. We have to have the will to find a way to pay for that evaluation before we're releasing those who have committed homicides into our community. And I would be attending those hearings or having someone from my office attend those hearings because I do think this is critically important. Lately, we've had a number of issues. The person who was convicted of murdering the nuns in Waterville.
Your time has run out, so I'll stop you.
I'll stop.
Mr. Banda, same question.
On this particular issue, I will say that from what I've heard from Ms. Maloney say here tonight, I'm in agreement with some of the comments that she's made on this issue. You know, I think it's a tremendous risk to public safety for the community and particularly for the citizens of Augusta to have these individuals released into the community with very little to no supervision. Some of the things that you've been reading about in the newspaper with the release and what level of supervision are these individuals going to have, it creates a huge safety risk for the community. And quite frankly, being in the district attorney's office and seeing the vicious circle, the vicious cycle that happens when you release someone who has previously been found NCR, not criminally responsible, and then they're in some sort of a supervised or managed living situation, and they continue to reoffend. They assault their workers, they assault their staff, they may assault other people in the community. It's a vicious cycle because, quite frankly, the jail doesn't want them, and Riverview doesn't want them. Nobody wants them. So, you know, we need to take a realistic look at this situation and it's stop going through this vicious cycle that we've been doing with these individuals, where they get released, they commit a crime, they're found NCR, they go to Riverview, they're released into the community, and now we deal with situations all the time where they're reoffending. And what do we do with them? And can we even prosecute them effectively with that prior NCR finding? It's a problem. I think it's probably one of the top safety concerns that the district attorney has, and it's an issue that needs to be addressed.
I have a question from the audience, and I'm going to ask it because it's such a specific question, and it wasn't one that occurred to me, so it sort of caught my attention. It says, there have been many pharmacy robberies in central Maine reported in the news lately. What would your sentencing recommendation be for these types of cases, Mr. Banda?
Well, that's a great question. I mean, this seems to be the trend. You know, when I was in the DA's office here, it seems like the drugs of choice have changed. You know, we used to have the I-95 corridor where the drugs would come up and it would be cocaine and crack and some other things. And now it seems like the trend is the popular thing is the pills. Let's go rob a pharmacy. Well, with everything that's been going on, the U.S. Attorney's Office, the U.S. Attorney, former Justice Delahanty, basically went to the Maine prosecutors and said, look, here's the deal, folks. There's inconsistency on what you guys are doing in sentencing, and we need to straighten this up. So come up with a proposal, a model sentence recommendation for your, basically your low-level robbery, Class B robbery, no weapon, no injuries, no prior criminal record, and the person's not on probation. Come up with a model sentence, because if you guys don't get on the same sheet of music, we're stepping in, and we're going to take these cases federally. The District Attorney's Office did that. All the prosecutors' associations did that, and they've come up with a model sentencing recommendation that all have signed on to of 8 years, all but 4 years suspended, and 3 years probation. That means a person gets sentenced to 8 years, they've got to spend 4 initially, and when they get out of jail, they're on probation for 3 years. Now, mind you, this is just the low, what we call at the baseline. This is the line in the sand, folks. The line in the sand below which we do not go. That means that's the lowest. If they've got a record, if somebody got hurt, if they've got a firearm, the sentences go up. They do not go down. But this is the line in the sand that the U.S. Attorney's Office has accepted, and they have agreed to stay out of prosecution of pharmacy robberies, because they actually did a study, and they said, look, if we take these cases federally, we've done the analysis under the federal sentencing guidelines, and we think we'd get about the same sentence, that is 8 all but 4, on these cases as they would get in state court. So that's why that agreement was in place. That would be the line in the sand, 8 all but 4. You get any one of those circumstances, weapon, injury, criminal record, or the person's on probation, fasten your seatbelt, folks, because they're going for longer than that.
Ms. Maloney, same question.
Thank you. And I do also agree with the statement on working together to come up with recommendations that we can work on through statewide. I do think that when one county has dramatically different recommendations than another county, that it's extremely difficult for us to be able to move forward in taking a strong stand on these issues. The only problem is that we're already hearing about crimes. We just had in the paper this week in Mr. Wilkins, where he robbed a home, not a pharmacy robbery, but a home, broke into the home, had a gun, had a knife, threatened the people who were living in the home, and robbed them. He was given 2 years in jail. I just simply think that's inadequate, that it's not sending the message that we need to send, that when people don't feel safe in their home, that's a violation that's unacceptable. So I want to work with other district attorneys in trying to get a uniform message that we can send on these cases. I think that is the way to go. But we need to make sure that we are doing that across the board for home robberies and for pharmacy robberies. Now, because my time hasn't run out, I just want to quickly speak to the domestic violence issue. I have heard from those who run the men's work program that the deferred dispositions in domestic violence are not effective because the people who are in the program do not take it seriously. The solution to that came at the Domestic Violence Speak Out in Skowhegan. Deputy Sheriff Mike Pike is willing to supervise those on the domestic violence deferred disposition. So it's important that we're in the community, that we're going to these events so that we can hear these solutions. Because with supervision of these deferred dispositions, then we can turn things around and have people cooperating in the programs that they need to be in.
The next question is sort of a spin-off from some of the discussion that you just had. And what I heard was that the sentencing recommendation for someone who's committing a pharmacy robbery would be 8, and 4 to be served, assuming they had no prior record. Sometimes those folks are, and often, I guess almost always probably, substance abuse is a problem. Sometimes it's mental health together with substance abuse. And we have in Kennebec County a co-occurring disorders court and a veterans court, which is designed to deal with some of those issues. And so it just sort of, how would you square those two provisions? And what, more broadly, what is your view of these problem-solving courts, as I call them, and how would you plan to make use of them during your tenure? And I guess you're the first answer here. So, Ms. Maloney?
Thank you. I am a big fan of the Veterans Treatment Court, as you've heard in my opening. I believe that we need to allow our returning heroes to have an opportunity to turn their lives around. And it helps the community, it helps them, and that these alternative courts are ways of doing that. It's ways of holding people responsible for their crime, but at the same time giving them the ability to rehabilitate themselves and to turn their life around. I have been to the Veterans Treatment Court and to the Co-occurring Disorders Court. I've talked with the people involved in both programs. And one of the things that's really exciting to me with the Veterans Treatment Court is that we have the opportunity to get federal funding through that program. I've written grants in the past, and I've received a grant for nearly $100,000 for my community. I'm looking at grants that we can obtain through the Veterans Treatment Court. Been working with Congressman Michu's office to get some of this federal money. And what happens when we get money for the Veterans Treatment Court is we also get money for the Co-occurring Disorders Court. Because of course they both take place in the same building, the same justice, the same prosecutors involved. And so when you help one, you help both. And my goal I've been talking with other district attorneys in the state as well, my goal would be to see the Veterans Treatment Court in every district in the state, and to also work to expand these alternative treatment courts. I'd love to see a drug court in Skowhegan. I think it's a shame that we don't have one there, and so that would be one of my priorities as well.
Mr. Banda?
Let me just preface what I'm going to say by saying, first of all, I am a veteran. I served my country in the Maine Army National Guard as an infantry officer, and almost every one of the men and women that went overseas to serve in Iraq and Afghanistan, I got to look them in the eye to eye, and talk with them probably about the last thing that they wanted to be talking about before they got shipped overseas, and that is, as an attorney in the military, you've got to deal with what happens with their affairs when somebody dies. So I am a veteran, and I have a great appreciation for our veterans. And let me just say this. Before the Veterans Court was brought into being, and with all due respect to Ms. Maloney, and this has to be said here tonight because it hasn't been said yet, Ms. Maloney did not create the Veterans Court. The Veterans Court was an offshoot of the Co-occurring Disorders Court that was implemented by Justice Nancy Mills. Now, that Co-occurring Disorders Court was in place when I was at the DA's office, and it was in place for a very long time. And they started to get veterans into the program, and it was sort of a natural progression where some veterans were there, and some veterans applied to it, but they didn't have the dual diagnosis, they didn't have the mental health and the substance abuse, so they were ineligible for the court. And ultimately what happened is they broke off, and there was a separate piece that they started to call the Veterans Court. That was in place before Ms. Maloney came onto the scene in January. She put a label on something that already existed. And she's taking the credit on the backs of the hard work of other people that have worked in this criminal justice system, like Nancy Mills, like Sheriff Liberty, who are the people who implemented the Veterans Court. So that being said, the question was, what are you going to do with robberies if they've got these issues? You commit a robbery, you're going to jail. You're not going to the Co-occurring Disorders Court. You're not going to the Veterans Court. You commit a robbery, you are going to jail. And that's my answer.
Once again, let me go back to the sort of the mundane, everyday affairs and get bail decisions are often very difficult in deciding whether to oppose bail or to make a recommendation with regard to bail. And so can you give us a sense of your views on bail, and I'm talking about prior to trial, not bail pending appeal, which is a different kettle of fish. And sort of how do you balance the risk of flight or non-appearance with community safety? And let me sort of point that up a little bit more, perhaps for some of the audience. It's been my experience that there are people who commit crime who are perfectly trustworthy. They will show up without fail. I don't know that you could drive them out of the state. They're right here. They're perfectly happy at home, but they have a tendency to keep committing crimes while they're out. And so if you're just looking at it in terms of what is the likelihood that they're going to show up, 100%. What is the likelihood that they may commit another burglary while they're out on bail? Pretty high. So what is your view? And Mr. Banda, I think it's your first answer.
Pre-conviction, post-conviction? Or is it
pre-conviction.
Pre-conviction. Well, pre-conviction bail, the statute, and people, this is sort of a very hyper-technical area, but let me see if I can break it down and sort of explain it in layman's terms. In the pre-conviction context, now this is for people who aren't on probation, okay? You're entitled to bail. The statute, our law says you're entitled to bail as a matter of right. But then it sets forth a number of exceptions and a number of analysis that you have to go through to determine whether or not any amount of bail, cash or surety, is set instead of what we call personal recognizance. The presumption is personal recognizance. That means you promise to appear. You go through all the analysis to determine whether cash bail is needed. That's done on every case, on a case-by-case basis. The primary concern for the district attorney, the number one core concern, should be public safety. I know my opponent has said, and she said before, that she wants to release nonviolent offenders, or she's interested in finding ways to release nonviolent offenders who are being held on bail of $1,000 or less, misdemeanor offenses. And quite frankly, it demonstrates a misunderstanding of the process. Most people who commit nonviolent offenses who are not on probation do not get held on $1,000 bail. Most people are out on far less than that. The problem that's created with overcrowding at the jail is we have a lot of people on probation, and when they violate probation, they go back to jail. When they go back to jail, they're allowed to have an initial appearance on that probation violation. But it's not, they're not entitled to bail. So I think Ms. Maloney is confusing her statistics. Most of the nonviolent people that are in jail that can't make bail of $1,000 or less are there, most of them are there for probation violations. Even if what she says were true, it doesn't make sense to let people out because there is a day of reckoning. In every case, there is a day of reckoning. There will come a time when your case will be over and you will be sentenced. And so if you've got a misdemeanor offense that gets a 30-day jail sentence, they're going to go back, if you let them out on bail, they're going to go back to jail and serve their 30-day sentence. If they're unable to make their bail because they're a thief and they steal and steal and steal and steal, and they've got a $500 cash bail but they can't make it, they get that if they get sentenced on day 10, they just get that same 30-day sentence. The law provides that they get credit for that 10 days. So it's a zero-sum game. Letting people out of jail early does not save cost because they wind up going back to jail later on to serve their sentences anyway. And that, I think Ms. Maloney doesn't understand the full picture in that respect.
Thank you. Ms. Maloney.
Thank you. This is a perfect example of what happens when you think you know all the answers and so you're unwilling to talk to people and to find out what really is happening. I am always willing to talk to other people and to ask questions, and I'm always willing to learn. I talked with Bob Devlin, who's the county administrator for Kennebec County, and he told me that over 50% of the people in Kennebec County Jail are there on a bail amount of $1,000 or less for a non-violent misdemeanor crime. And what happens is not that somebody is eventually sentenced to 30 days and they've been waiting for their trial date for 10 days, but what can happen is someone can be sentenced to 1 day or 2 days, but they've been waiting for their trial date for 10 days. That's an injustice. And when that happens, people feel forced to plead guilty to a crime that they did not commit just so they can get out of bail. I don't believe in holding people in jail just because they're poor. We have a program set up to deal with this. It's the Pretrial Services Program. It is being underutilized. We have it both in Kennebec and Somerset County, and I think we need to expand it. We have a 98% success rate in people not only coming back for their trial dates, but not committing another crime while they're out on bail. Now, I do need to address what was said on the Veterans Court. The Veterans Court was created in Buffalo, New York. Congressman Mike Michaud, as a member of the Veterans Committee, he visited that court. It was last year during a hurricane that we rode together to the Muskie Lobster Bake that Congressman Mike Michaud told me about the Veterans Treatment Court that he went to visit in Buffalo, New York. I immediately asked him if I could introduce this bill in Maine. He said yes. I called up Mary Ann Lynch, who is the coordinator with the court system in the legislature, and she said that she loved the idea and she would immediately talk with Justice Mills and other in the court about it. So that took place a little bit over a year ago when we had those conversations. The Veterans Treatment Court, what the bill did is it put in law the ability to set up these courts throughout Maine. It put in law the ability for us to apply for federal grants and to give us a stronger standing when we do so.
Your time is up. Thank you. If there are more questions in the box, could you bring them down to me now and I'll look at them. I have a couple of questions from the audience that we'll work on while I'm reviewing those, which are largely ones that never occurred to me. So I would ask this one, and this is for you first, Ms. Maloney. What is your opinion of Maine's medical marijuana program, and how could it be improved? Thank you.
Well, as I always say, whenever anyone asks me for my opinion of any statute, then I'm actually not running to change Maine law, I'm running to enforce Maine law. We have a medical marijuana statute that has been passed by the voters of the state of Maine. That is the law that I will enforce 100%. I'm not sure that there's anything else to say on it, that I will enforce the statute as written. I think that that was the decision of the people of the state of Maine, and I'm not going to second guess their decision.
Mr. Banda?
In one respect, I agree, and then in another respect, I disagree. I agree in the sense that the district attorney enforces the law as the legislature gives it to us. So we've got a medical marijuana law. If you're in compliance, you're in compliance. If you're not in compliance, watch out. Now, that being said, there's a huge problem for law enforcement with medical marijuana. Because as I remember from being a prosecutor, as I'm lying in bed at 3 in the morning, and I got a call from Jeff Wrigley, who used to work at the Kennebec County Sheriff's Office. Hey, Derek, I got a search warrant for you to review. And I've got to decide if I'm going to sign off on this thing so that they can go kick somebody's door down. We're now presented with a unique problem with medical marijuana. Because there's no way for law enforcement to know when they are dealing with someone who is in compliance with the statute. And that is because they are no longer required to register with the Department of Health and Human Services. That idea went into place because it was thought that they were forcing people to incriminate themselves under federal law, because federal law says that possession of marijuana is a crime. And so we're now in a situation where people who are in compliance with Maine law are not being required to register, so that when law enforcement gets a tip and says, hey, I've got some information here that Joe Smith down the street's got a marijuana grow in his basement. And the officer not only hears it from one person, but he hears it from 2 people and then 3 people. And he begins to compile information to draft a search warrant. And then that officer needs to know, how do I find out if this person is actually a medical marijuana user? How do I know if they're a care provider or caregiver? Who do I call? The answer is no one. And what happens? We kick down the door. And we execute the search warrant. That is a problem. That is not what the people of the state of Maine intended when they passed the medical marijuana law. And it needs to be fixed. And do you think it would give me pleasure to do that, to answer that question as district attorney? No, it wouldn't. Because we want to know when we're signing off on a search warrant or we're approving for somebody to get arrested, we want to know whether we're enforcing the law justly. And right now we can't.
Thank you. Your time is up. Ms. Maloney, same question.
Oh,
She answered it.
Oh, I knew that was going to happen to me tonight. I was reading, okay? I'm so sorry. There happened to be a good question here, and I was sort of cogitating on that. And this is sort of a combination, but this question added something to mine that I had. I plan to ask you, and at this stage, it's your answer. How will you address the need for staffing that will be present when you take office and balance all of your other responsibilities with the reality that you must run again in 2 years? And the audience question that adds to this says, with reduced budget and staffing, what change management strategy will you use to facilitate this transition? So hopefully you got the gist of that combined question.
Sure. The personnel issue, and many of you have read about it in the newspaper. All of the assistant district attorneys that have left this office or are leaving, and as I look around the room, these are people that I work with. They're my colleagues. They're my friends. I see Steve Parker sitting right here in the second row. I see Patricia Poulin sitting here. I know there were some others I saw come in the room. Oh, there's Neil McLean up back. These people are leaving. That's a problem. This office has lost, or will lose, when this is all said and done, 150 years of experience, of trial experience. We were the model. This district was the model of prosecution, and this election has devastated that office. And it makes me sick. And you know, it's the biggest challenge for the next district attorney is personnel. And what are we going to do? We're going to have to find quality people. Maybe some of the people who have left will come back. And I see Paul Rusha, I forgot to mention his name, Paul Rusha is sitting in the back. You know, we're going to have to find quality people to either fill those spots, or some of the assistant DAs that were there might be willing to come back. But you've got to have quality people, and the challenge is, with the amount of money that they can be offered for a salary, because believe it or not, assistant DAs don't make a lot of money, with the amount of money that we can offer people, it's very tough to entice lawyers from the private sector to come over to prosecution and work for less money. It's a challenge. And that is why experience, again, is so vitally important in the distinction between myself and Ms. Maloney. I am going to be a working district attorney, because this next elected district attorney is not going to have the luxury of sitting around the office in Augusta and answering phone calls or going to the legislature or going to various meetings. The district attorney is going to have to be in the courtroom handling cases, because quite frankly, we are not going to have the luxury. So the district attorney is going to need to hire quality people, but most importantly, have the experience to be in there doing the cases him or herself, and have the wisdom to know who to hire. Thank you.
Ms. Maloney?
Thank you. I also think it is unfortunate that the people who are in the district attorney's office are leaving. I wish that they would stay. I also see the people here from the district attorney's office. It's great to see them. I'm glad they're here, and I hope that they're listening to everything that we talk about. And I see people here from the attorney general's office that I have worked with, and I appreciate seeing them here as well. We absolutely need to look at the staffing issues. I was happy to speak with those who work in the Skowhegan office. They are staying, so we have no staffing changes in Skowhegan. I have talked with the people in Waterville. Tracy is staying in Waterville. And then I've also looked at the district court in Augusta. We have 2 people there who are going to be continuing to work in district court. Where we really need, where we're going to have new people is in Superior Court. And I've had a lot of people approach me who would like to work in those positions. Neither one of us is in a position to be able to make promises, but we hear from people. And so I know there are people with many years of experience who are interested in those positions. However, knowing that this problem is coming up, I think it's important to be proactive. And so I talked with the Attorney General, and the Attorney General told me that he would be happy to have people in the Attorney General's office working with us day one to make sure that that transition is smooth. This is something that my colleague and I disagree on. At our last debate, Mr. Banda said he would not allow the district attorney to help with the transition period. That's something I simply don't understand. This isn't a turf war. This is about working together to make sure that the people in Kennebec and Somerset County are safe and that criminal justice goes forward. I also found it insulting to hear that Mr. Banda would be a working district attorney, as though the last 30 years, the district attorneys that we have had not been working district attorneys. I think that's untrue. Even though they were not trying cases in the courtroom, they were hardworking. And I do agree, however, that I would also need to try cases in the courtroom in addition to the other duties of the district attorney.
That sort of presents a segue into my next question. I may have even partly answered it, but I'll give both of you a chance at it. My question really was, will you personally handle trials in court? What kind of trials, and how many of them? And I would just re-emphasize that, in addition to everything else that we've just talked about, that because the term is 2 years, whichever one of you wins is going to be running again in 2 years. So you've got it's not a lot of leisure time in there. So the question is, will you try cases? And if so, what kind and how often?
So the answer is yes. And the other answer is whatever best helps the office. Wherever I'm most needed in the office, that's where I need to be. I'm not looking to take the glamorous cases away from people. I'm looking to try whatever needs to be tried to help the office to run smoothly. We are looking at moving to the unified criminal docket. I've talked with Justice Softly about this, as well as Justice Silva, so that the way cases are tried in the office will be changing. It will no longer be that there are those who exclusively try district court cases and those exclusively try superior court cases, which I don't think is the best model anyways. I think it's important that everyone in the office be able to try both types of cases. So with the unified criminal docket, the cases will be assigned as they come in, and everyone in the office will have the experience in trying the different types of cases. So they'll be assigned as far as how people are along in their workload and who has the time to take it, and I'll be putting myself in that rotation to make sure that I'm helping out the office wherever I can.
Mr. Banda.
Well, you know, there's not going to be anybody to fight with to take the glamorous cases because they've all left. I mean, the electorate elects the district attorney because you expect a certain amount of leadership. And for the district attorney is the managing partner of a law firm. Okay, let's define it for what it really is. The district attorney office is a law firm. And the elected DA is the managing partner. And it's not the unified criminal docket, it's not Chief Justice Softly's implementation of the unified criminal docket that decides who in the district attorney's office takes any one particular case. It's the district attorney. I mean, the unified docket's in effect in Cumberland County and York County, and I've been working down there, Megan, for the past 5 years, and I haven't seen you down there. And that unified docket process does not affect who in the DA's office is assigned the case. That responsibility is with the district attorney. And that's why I say it's ever so important that we elect someone with experience. And I think it's disingenuous, Ms. Maloney, that you've sat here and you've told these people, you've created the impression that you have tried cases in Augusta, Waterville, and Skowhegan, that you have tried jury trials. And I think these people here would like to know when your last criminal jury trial was. Because I think the answer is it was in 2000 when you were in the state of Oregon. And if that's the case, that you haven't tried a criminal jury trial in 12 years, and now you want to step into the role as chief prosecutor, chief law enforcement officer for the district, and you intend to manage a law firm of other trial attorneys, that's a problem in terms of experience and judgment and knowing who has the best skill sets and the best experience to be able to handle any particular case that comes in the door. And these are serious cases. And let me just say this. I'll save it for another. My time's up.
I have a question from the audience. What is your position with respect to restorative justice, and how do you feel the DA's office could utilize it, if at all? And I would just add to that, all of us may not understand what restorative justice is, but I would just add to that the same question with regard to the possibility of victim-offender mediation as a possible type of resolution. Mr. Banda.
Yeah, I mean, we've had, if you want to, I don't like these labels. You know, we tend in society to use a lot of slogans, and we tend to use labels and things that sound nice and sound bites. Let's just talk in real terms and real world terms about what we're doing. If you get someone that comes in the door that's committed a crime, we have to decide, remember what the analysis is. Did a crime occur? Can we prove it? Should we prosecute it? And what should the sentence be? That's the analysis. We don't need any fancy labels to go through that analysis. And so if we're talking about being creative with people, instead of just sending everybody to jail, because I don't want the perception created that I'm just here wanting to send everybody to jail. I mean, don't forget where I've worked for the last 5 years. I've worked with Dan Lilly at the citadel in the citadel of the defense. Okay? So, I mean, there are a lot of creative alternative things that we can do with people. You know, and let me give you an example. We have, this was implemented by David Crook and Everett Fowle. We have the Pine Tree Camp, where, you know, you get somebody that commits an offense, and they're a good person, and they had a lapse in judgment, and we sent them to the Pine Tree Camp to pound nails and fix roofs all summer, instead of branding them a criminal all their life. You know, if you get an 18-year-old kid that breaks into a hunting camp up in Jackman that's unoccupied for 11 months out of the year because he's looking for alcohol, do we convict that 18-year-old of a Class B burglary, a felony, and brand him a felon for the rest of his life? Or do we send him to the Pine Tree Camp for a summer to work his tail off, to make amends for what he did and send the message home that this behavior is not accepted, but we set him on the right course without branding him a criminal? Those kinds of programs have been in place. All those creative things have been in place. And I don't want to take credit for things that my predecessors have done. Everett Fowle, David Crook before him. We can do better. You can always do better. But there's a lot of creative programs that are in place and that I will continue to support. And that includes the OUI first and second offender program, where first offenders and second offenders who commit OUI don't go to jail. So.
Ms. Maloney.
Thank you. I am tired of my opponent's approach being all about negative campaigning. I think people are sick of that. I have not gone that route in my campaign, and I am tired of hearing about it. However, I will share with you what are the duties of the district attorney, which talks about primarily there are civil proceedings and there are criminal proceedings. We have not heard one word from Mr. Banda about his experience with civil forfeiture law, which is the #1 request of the Fraternal Order of Police and other police agencies. We have not heard one word about how he will deal with the other civil cases. This is 78 pages of civil law that the district attorney is responsible for handling. Yes, we handle criminal law, but we also handle civil law. And some of the things that we handle are things like tobacco products tax, things like the cigarette tax, the Freedom of Information Act, and the elections law. Now, as far as looking at jury trials, I started off in the Attorney General's office in the litigation department. I handled tax litigation, I handled bankruptcy work, I handled work on the multi-state tobacco litigation. I can tell you about some of my tax litigation trials. These are jury trials. These are trials where we have to work to build a case. I worked for months to build a domicile tax case where people would be accused of saying that they lived in another state when they actually lived in Maine. These were cases that were very fact-intensive, that took a lot of deposition work, that took a lot of work in subpoenaing their documents. And when we went to trial, the whole case surrounded whether or not we could convince the jury that the jury needed to find that this person, that we needed to make sure that the jury bought into the fact that, hey, when you violate the tax code, that hurts all of us. That is the argument that I would use, and that was very successful. And so, but I am trying to keep this campaign positive, and I wish my opponent would as well.
Can I respond to that?
And let me just say, as far as where have I been, not in Cumberland County, not in York.
Your time is up.
But I've been here in Kennebec.
Your time is up. Thank you. And I'd ask both to stick to the questions, okay? One of the most complicated or difficult issues, it seems to me, that a district attorney faces is in juvenile cases when and if to seek to prosecute a juvenile as an adult. And so I would ask you, Ms. Vallone, under what circumstances would you move forward and choose to prosecute them as an adult?
Thank you. That's an excellent question. During this campaign, there was a 2-day conference that took place in Kennebec County in Augusta that was exactly on this topic. The conference was about what are we going to do about the sentencing of juveniles, when do we treat them as adults, and what alternatives do we have in dealing with juveniles. This is a conference that was attended by 10% of all the trial judges in the state. It was attended by Chief Justice Softly. I was there. My opponent was not there. And I do think that this, and it was a national conference that was presented here in Augusta. So I would follow the recommendations that I learned, because this is the cutting edge that people are following. This is, we're looking at changing the way that we view juveniles and realizing that unless they have committed a capital crime, that we need to try to rehabilitate. And even with the conservative Supreme Court that we have today, we just received an opinion from the Jackson versus Hobbs and Miller versus Alabama from the Supreme Court saying that we're not going to allow mandatory life in prison without parole for juveniles, that they overturned those statutes. And I agree with that philosophy, because if there's anyone that we can help, it is juveniles. Those are the people that we have to put most of our rehabilitative efforts into, and was glad to see that the Supreme Court went that direction and that we are having national conferences and national discussions on making sure that we do everything that we can to have programs and processes in place for juveniles.
Thank you. Same question for you, Mr. Banda.
We don't have lifetime parole for juveniles in Maine. I've never heard of that. You know, juveniles are...
That would be if they were prosecuted as an adult. The question is, when would you seek to prosecute them as an adult?
And that is a very that's a very delicate thing to answer, I think, because the juveniles are youth. They're typically people, they're obviously children, and the stance I think that I would take is, unless there is a death, or B, a juvenile who has a repeated history of violent crime, I would not seek to have them prosecuted as an adult. And in fact, the process for doing that, the bind over, the process that you have to go through in court is actually quite stringent. And the standard is actually pretty tough. Even if the district attorney wants to prosecute someone as an adult, it's not that simple. It's not just, well, let me see and decide we'll do it. There's a very complicated process, court process, that you have to go through. And that's one of the tenets of our juvenile system that's been in place. It's nothing new. But to answer the question very specifically, sticking to the question, unless there's a death involved or the juvenile has multiple history for violent crime, a history that would warrant or justify holding them over as an adult, then I would not prosecute them as an adult, except in those narrow situations.
One final question, and if you can keep your answer short, it will help us finish on time. What are your views on what is often called the insanity defense, Mr. Banda?
Well, I tried one just recently, and if we want to talk about veterans, my client was a veteran, and you may have heard about this case. Dan Lilly and I represented a gentleman by the name of Bartolo Ford a couple years ago, and he was an Iraqi war veteran, and he was prosecuted because he went on a rampage one night, smashed into some police cruisers, high-speed chase, hid in the woods from police, you name it. It was a pretty case that got a lot of immediate attention, at least in the Lewiston, Auburn area. And we presented a mental health defense. There's actually two kinds. There's what we call abnormal condition of the mind, and there's also the more traditional insanity defense, not criminally responsible. We presented one of those defenses. It was an abnormal condition of the mind defense, and I think that they're absolutely legitimate. It's an absolutely legitimate part of our criminal code. It's a necessary part of the criminal code because you have to remember what crime is concerned with. Crime is concerned with what is in the person's mind, and it's that mental intent. That's what makes something criminal. What is going on in the person's head? And so if they don't have the capacity to understand what they're doing, our law says that they're not criminally responsible. So it's an integral part of the criminal code, and it's something that I've been intimately involved with in trying criminal jury trials, not tax cases, not guardian ad litem cases, but trying these cases, aggravated assault cases and such like that, the business that district attorneys do.
Thank you. Same question.
Thank you. We have a huge problem in the criminal justice system with those who are mentally ill. And the reason we have this problem is because, frankly, when the only time that we can help people is when they are found not guilty by reason of insanity and they go to Riverview. But far too often, we end up with people who are mentally ill in our prisons. And there, they do not receive treatment. They do not receive any help, and it's a tragedy. I worked on a case where someone had been convicted of assault. He was mentally ill, but he was not found not guilty by reason of insanity. Instead, he was found guilty, and he was sent to prison. His mental illness caused him to be violent to all of those around him. The jail is not allowed to force medicate people in the jail. So the only way that they had to deal with him is by putting him in solitary confinement. He was in solitary confinement for 3 years. And then he was going to be released to an apartment in Portland. But instead, working with Senator Hastings, we were able to get him transferred to Riverview. But what happened for psychological evaluation? When he was transferred to Riverview, he assaulted one of the nurses and then was sent back to prison. We obviously did not help him. And we need to look at what can we do differently for the mentally ill in prison. How can we treat them? How can we solve this problem and do things differently? I think that's one of the biggest problems that we face in our criminal justice system.
Thank you. That concludes our time for questioning. And now, Mr. Banda, you have the first opportunity for a closing statement.
You know, it occurred to me. It occurred to me as Ms. Maloney was giving her opening, and the thing that she says encouraged her to pursue a career in the criminal law was a case that she described as someone getting injured by a drunk driver. Let me tell you what the day in the life of a district attorney is. All slogans aside, all gimmicks aside, let me walk you through it. You wake up at 6 in the morning. You try to get to the office early. You come into your desk and you've got a stack of reports on your desk, probably about this high, police reports from all various agencies that you've got to read through. And you've got to do that analysis. Who do we charge? What to charge? Should we charge? And while all that's going on, the phone's ringing. Police officers, victims, all types, asking questions. Can we kick down this door? I'm at the house. The ex-spouse says that my ex-husband won't bring the kids back this weekend. She's got a court order here saying she's supposed to have them. Can we arrest him? You get questions from victims. Well, I don't want to come to court and testify. If you subpoena me, I'm not going to show up. And in the meantime, you're trying to screen all the cases and get the work done. And then you get through the day, and maybe it's not a court day, and that doesn't include the days that you've spent on your feet, bringing a bucket that's about this large or this heavy with about 200 files into the courtroom, and dealing with every capable defense lawyer in the state on every case, and you handle every one. And they've studied it for 5 hours, and you've studied it for 5 minutes because that's all the time you've had to put into it with the caseload that you have. So maybe you've been on your feet all day, and you get through all that, and then you go home and you finally get to go to sleep. But the phone rings at 3 in the morning, and it's a call where there's a serious motor vehicle accident. And as a prosecutor, your responsibility is to drive out there in the middle of the night, and as I found myself doing, on some back road in Kennebec County or Somerset County in the middle of the night, being cold, being tired, not knowing where I was going, and showing up on a scene of just complete horror. A scene that you just want to go home to and hug your kids afterwards. And I can remember specifically one case, seeing bodies that were just completely crumpled, bones crushed, where the person's legs and arms just flapped like spaghetti. An accident so horrific that it ejected one passenger, sent them skidding across the pavement like you would skip a stone on the water. And the impact of their body hitting a parked car was such that it dislodged the hood from its hinges on the car. That was a drunk driver that killed a parent. Now, as a district attorney, you can't make the children of those parents, you can't reverse that life. But you can sure as hell make sure that that son of a bitch gets where he needs to go. And who's going to do that? Ms. Maloney, or me. Because if it's Ms. Maloney, you're going to have somebody like
Right,
me or Dan Lilly or someone else on
up.
the other side of the case defending it, and she won't have the experience to prosecute it.
Your time is up.
Thank you.
Ms. Maloney?
Thank you. Thank you again to everyone for being here tonight. I will address at 3 in the morning, I'm often still already awake. So I wouldn't even be woken up when the phone rings at 3 in the morning. I'm the only candidate in this race who has tried both criminal and civil forfeiture cases. I am the only candidate trained as a guardian ad litem. I am the only candidate who has managed an office and worked on the judicial budget. I am the only candidate who won a national fellowship to spend a year working exclusively on domestic violence prevention work and has obtained a private grant of nearly $100,000 for her community. I am the only candidate who has successfully authored a bill to establish a new alternative justice program in Maine, the Veteran Treatment Court. I am the only candidate endorsed by Somerset County Sheriff DeLong, county commissioners, and 3 former attorneys general. I am the only candidate attending events such as the domestic violence speakouts in Kennebec and Somerset counties. Not surprisingly, I am the only candidate proposing a zero-tolerance policy for domestic violence, child, and elder abuse. I will fight for justice while holding an open hand to those who can be safely returned to our civil society. I will fight for justice in our communities because when you do not feel safe at home, you cannot truly be free. I will be smart on crime. Being smart on crime means that we seek the most safety for the least cost. Being smart on crime means that those who commit the most violent offenses go to jail for the longest time possible. But that can't be the way that we treat every case. Because right now, we are being hit with a tide of non-violent offenses that are swamping our courts. As District Attorney Ronnie Earl in Texas put it, district attorneys who do not differentiate between types of crime are not being tough on crime. Who they're being tough on is the taxpayer. That doesn't reduce crime. Once we realize the logic of a balanced approach, one that incorporates prosecution and jail time with the possibility for redemption, education, and working with victims, then we are able to look to a future where we can meet the challenges that right now seem grim and insurmountable. Because we can change the way that we can change the cycle of crime. We can feel safe in our communities.
Your time is up.
We can be safe on crime. We can be smart on crime.
Thank you. Well, ladies and gentlemen, that concludes our evening. I want to, first of all, say that I had never met either one of these people before, and I'm pleased to meet them. As a voter here in Augusta, this was a great job interview for me tonight. I could sit here and talk to these 2 candidates, and I hope that you folks felt the same, that this was really an opportunity to hear both and to have some of the serious questions that this position, and I do agree that it is one of the more important positions in our state, and certainly to those of us who live here. And so I hope that you feel like you've had an opportunity, and I hope you'll join me in thanking both of these people for being willing to undertake public service. Stand up. Thank you all very much, and on to the reception.